So who wants to speak on behalf of this group?
So at the outset, we'd like to clarify that this is a negotiating forum and we're not really looking at opposing principles, but any and all different viewpoints that are possible on these points. So one thing that we need to notice about the things that we're dealing with is that it's a very broad spectrum. So there is stuff all the way from enhancement to machine interfaces. So while working with it in future, what we need to understand is that there will be separate governing mechanisms for each type of this. But what we are doing right now is we're trying to provide a uniform sort of system which has basic guidelines on how to deal with all these sorts of, let's just call it transhumanism for a better choice of word. So some of the principles that we have come up with to deal with these questions is, at the outset, we believe that we need to have some sort of a gradation system in dealing with types of bioenhancements and types of alterations and gene editing which are allowed. A very basic differentiation we could make is between a category 1 enhancement, which deals with only, say, improving your hearing or just allowing you to maybe make you happier for a limited amount of time. So in all these considerations, we're not talking about therapeutical effects at all. We're only looking at things which are enhancing your capabilities. So medical uses are beyond the scope of this treaty as far as we are concerned. And your second gradation of enhancement would at the extreme level enable you to fly or give you all sorts of superhuman powers. So these two, basic enhancement and extreme forms of enhancement, are something that we need to differentiate between at the very outset. I think one of the biggest problems that we are going to face is this conflict between autonomy and the interests of the broader society and the systems approach. So while we do feel that the state should be given a very wide margin of appreciation in deciding what is applicable within the national territories, there should be certain broad principles that must be accepted across jurisdictions. And one of those is that the state everywhere should be subject to some sort of an international oversight mechanism in the form of a certification body that determines whether a particular scientific process is safe enough to actually be employed on human beings. And in this respect, there cannot be differences between national jurisdictions. So we're looking at something like ISI certification, which we have in India, or say drug testing, where you have clinical tests and those tests need to be approved before the drugs are introduced. We're looking at something of that sort at an international level. Then as far as this question of commodification and intellectual property is concerned, we are proposing that human enhancements are completely beyond the scope of intellectual property rights, and there is no IPR at all available for this. And there is also a compulsory licensing mechanism within the national jurisdiction on all these products. Then as far as the societal setup is concerned, since we're looking at a situation which could possibly place some limits on human autonomy, because questions of human dignity and equality must also be considered, we are considering the definition and creation of perhaps new crimes. Say, right now, interference with bodily integrity means actual assault or battery, but we could possibly be looking at a situation where you could have mental probes, which is also a violation of your bodily integrity, the violation of your mental space. So we're looking at the creation of an all-new criminal law regime, which would develop to tackle these sort of problems. Then also what we would like to propose is that all these enhancements and use of these technologies be on a temporary and reversible basis. So we are not looking at gene alterations at the embryo level, which will create permanent features which are going to be passed down to generations. So something reversible in nature. Then, as far as consent is concerned, like it's well established now that no man has a right to become a slave. Similarly, we're not looking at the creation of a master and slave relationship. Consent will be allowed to the limit that your individual autonomy is retained. So, by consenting to certain procedures, you cannot allow yourself to become a robo. So exactly what this level of robo is something which has to be negotiated and discussed. But as a basic principle, this is something which needs to be agreed on by all parties. We are a robo or a
under control of somebody else.
Yeah, you cannot lose control over your sense of me. You cannot become a mere puppet. So that's the broad idea of the consent. And lastly, we're also looking at, as far as international oversight is concerned, we're looking at a body like the HRC, like the Human Rights Committee, instead of a court-like mechanism, which is going to provide comments on how to interpret various articles of these treaties, because there is bound to be confusion, there is bound to be disagreement, at least in the initial stages of its working. So something that allows the international community to understand the standards that it's supposed to live up to. So this would be the broad framework that we propose. And yeah, also this one thing, we are also not looking at military use of human beings. So we do not want a situation in which you are allowed to create child bombs or maybe force people to lose such a sense of themselves. We know that we already have these things like suicide bombers, but we cannot have a situation of human enhancement, which is not technically. We're not saying that you cannot use enhanced techniques like the thing we were discussing about how you can go without sleep for 4 days. So if there is an enhancement that allows you to not sleep for 4 days, that's perfectly fine. But we cannot have a situation where you're creating bombs out of human beings. So that sort of militarization is something that we're against and warning against.
That's really, really good. Of course, there is the autonomy right to undertake a risk, and even if something isn't quite 100% safe, arguably you could make the autonomy right. That's my choice, let me go ahead with it. But really, really interesting, very comprehensive. Let's hear from the alternative legal advisor.
So when we're looking at a treaty like this, there are a few key principles that as a nation we would like to protect and see are reflected in the treaty itself. The first is the question of individual autonomy. We believe each person does have a right to make individual choices, but at the same time they must also be, that autonomy is not pervasive. There are limitations on it, and so we take a middle ground in that regard. We are committed to equality and non-discrimination. As a country, we have faced deep-seated inequalities in society and economically, and so that is something we will keep at the back of our mind when we're laying down the scope and the rights and obligations of parties. Access is important. As a nation that requires constant interaction between states to help us with coming up with these technologies, monitoring these technologies, benefit sharing and access is something we would like to see reflect in this treaty. And the scope that we see this treaty covering is, so this is similar to what they said. We see a whole range of bioenhancements in question here. We thought we could make a distinction between permanent alterations and temporary alterations, and a distinction between medical requirements or medical necessities and voluntary enhancements. Whereas if it's a medical necessity, it wouldn't be fair on our part to restrict its use, and if it's required, it should be done. If it's a voluntary bioenhancement by a person, there is a cap on whether it's a temporary enhancement or a permanent enhancement, and that will translate in the treaty itself. When it comes to rights and obligations of the parties, initially, because this technology has not been tested and we're not sure when it's coming into force, and we're not sure of the state of technology itself in the market at present, initial use and sale we believe should be more regulated, and then based on the body, which we will create a national body and an international body, depending on the kind of technology, its safety, and whether it's a safe technology to be using, its regulation could be reduced. It could be deregulated and sold in the market more freely. There should be very strict norms in place to prevent misuse of these technologies. There must be a protection offered to vulnerable people. Consent is essential in these processes being used. And again, benefit sharing, full disclosure, and compensation in case of damage being caused to individuals or subjects part of a clinical trial research or genetic testing research of some sort. There should be very strict oversight mechanisms. We believe a body at the national level and at the international level should be in place to make sure these technologies are safe. At the national level, it should regulate both research and regulation and use of these bioenhancements separately. And this body, we believe, should be tasked largely with the creation of a secure, protected database of all of this information, which must remain private and anonymous. And it should be tasked with rule formulation and act as a complaints committee and monitor bioenhancements given to each individual. So reporting requirements should be very, very stringent in these cases. Also strict, there should be a mechanism for judicial enforcement of these rights, and that should be reflected in, say, law or constitutional values, so that people affected by these sorts of enhancements have some redressal mechanism in place as well. Does anyone want to say anything else?
So both alternate legal advisors see autonomy as a limited, bounded concept, not utterly open-ended, because there could be intergenerational damage, and so on and so forth. So that's interesting. You guys, I think, said something about, maybe I'm just putting words into what you said, surveillance and the right not to be tracked and the right not to be. Were you saying that? No? No? Okay. Sorry, I'm just imagining it. And you raised the whole equality issue, particularly equality of access, which kind of assumes that there will be some layer of socializing the availability of the technology over time, which is really, really interesting, as well as legal remedies at the end of the day. Anything else you want to bring up in each other's perspective? No?
It's really interesting, because if you're allowed to, say, even if you're introducing just a microchip in somebody's body, then technically the owner or the person who introduced the microchip has a mechanism to track your movement. So that is a blatant violation of privacy. So I'm not sure if you're looking at technological means to prevent interference or regulate the use of that technology, because if it's used by the state, that technically means that the state is omnipresent and can regulate every aspect of your life, because they know that what you're doing at every point. So yeah, that's a very
And I think there is another aspect to this whole exercise, because if there are certain bioenhancements which give a person superhuman powers, then also the state might feel a need to monitor them. How then, to what extent such persons' privacy rights are being respected, where the fine line between their privacy and societal need to monitor them, how those two are being balanced, this is also a very interesting aspect.
And this point about us being an emerging scientific prowess, so there is essentially going to be a disparity between the relative powers of different states, different countries. And so the equality argument is not something which is to be addressed only within the nation state, but also among the global community. So are we looking at something of an SNDT regime in bioenhancements and technologies, or maybe mandatory technical assistance, or provision of financial assistance? So what are we going to do to make sure that everybody is on a level playing field, or is...
By the way, there was a report on intellectual property and genetic editing on the UNESCO website, if you go onto it, which is really, really interesting. But if you have some sort of regime of technical assistance and cooperation between states, you're going to bump up immediately against intellectual property rights of large companies who wish to retain property rights over their innovations and so forth. When I was talking about surveillance, what I was thinking about was in terms of if you have the radiation reading devices that allows somebody to remotely track your brain waves, and we're pretty close to that because they have these devices now that don't necessarily have to be fitted to your head. They could be 10 feet away, but not much further than that. But you can imagine in the future if that could be embedded in your cell phone, and your cell phone could be tracking your thoughts throughout the day. That's exceptionally useful data to be used in big data banks by large companies. And that's not a million miles away, that technology. That's right around the corner. And neural surveillance is a distinct possibility. And of course, the abuses of that are mind-boggling to reflect on. Anybody else? Any other issue you want to emphasize, accentuate? I think it's fascinating how you've both, from the get-go, placed limits on the concept of autonomy, and what you've done is implicitly rejected the kind of more extreme individualistic interpretation of autonomy in the transhumanist declaration. Would that be a fair surmisal? Yes. Okay. Without further debate. All right. And I think you're absolutely right to separate out all of the different interventions because the principles will apply differently in those different particular applications. But that's not to say that you can't come forward with general considerations and then tailor them to the actual individual enhancements or whatever you want to call them. Bearing in mind that, who said that if your emotional capabilities are turned up to the max, that might mess around with the natural balance between your other capabilities? But that, of course, depends on what do we mean by natural. Isn't it up to us to change the natural mix into the future? And so what if I begin forgetting my wife's birthday so long as I'm happy, right? Actually, I won't be happy very long if I forget my wife's birthday. So I want you to take the next logical step. And this is what we'll talk about tomorrow. I want you to actually put down in draft headings what the treaty will look like and actually draft it. And I don't mean anything more than 2 pages, right? So consistent with your overall parameters, maybe each of you would go away and draft what you think will be in the treaty. And I don't mean statutory language because we're not at that stage yet. I mean the draft headings. We'll talk about that tomorrow and then maybe negotiate a little bit some of the rough edges where you're, let's say, in contradiction with each other to see if we can come up with some sort of unified approach before he or she gets on the plane to New York to actually negotiate on behalf of India. None of you actually mentioned business exigencies and the concerns to not regulate too intrusively so that you scare away multinational investment in Bangalore or wherever. Is that a consideration at all? And even if it is, how does it play out in terms of how you think through your negotiating principles? Sorry? No, you can't, but you can be alert to when other delegations are going to come along with too onerous regulations that might make India unattractive. What you want to do is, to put it bluntly, dumb down the obligations to the point where you actually have a natural advantage and then play on that into the future. Think about it. Because when states come to these negotiations, they always come to it reflecting on their own national situation, their own national priorities, economic development, as well as the deontological issues like what are the core principles of human rights. And for example, I'm not suggesting you're saying it, but one reason to opt or adopt for a more limited conception of autonomy is precisely because you think that will legitimate the emerging field, and then you will play to your natural advantages and attract even more dollars into your investment community. I'm sure the Minister for Economic Development will have a chat with you before you get on the plane. Sometimes, you know, as a lawyer, that's a dilemma because it kind of corrupts your mission, but it's also a practical reality. And your ethical responsibility as a lawyer at some point in time is to walk away from that. But by and large, it's part of your everyday job, so get used to it. All right, so draft your treaty, 2 pages, no more. And let's talk about it tomorrow, and let's see where the wrinkles are between the different versions and see if we can negotiate a final text before you get on the plane. Okay? Yeah. My preference would be you do it as a team, but I'm not sure that's possible because some of you... Is that possible? It's possible. Excellent. Put it all together. Okay. All right, let's do that. I mean, if you could meet separately for maybe maximum an hour to put something together, that'd be really useful. But if you can't, we can do that way as well in the morning. Yeah. Okay? So it's up to you which way you do it, so long as we get it done. All right. I'll be in my office for the next 2 hours if anybody wants to come talk about a paper. I'll probably be away like around 2 o'clock, but from now until then I'll be there. Okay. Okay, I didn't know that. My autonomy is limited. Okay, thanks very much. So, see you in the morning. And happy